I'd like to begin by acknowledging the Ngunnawal and Ngambri people, pay my respects to elders past, present, and of course I love the ones who are emerging. Paul's clearly very much emerged, but seeing the next generation is absolutely special. And also to acknowledge any Indigenous guests that are joining us this evening, or online, if it's online. Is it online?
It will be next week.
Okay, next week. For those who are watching afterwards, if you're in our Indigenous First Nations group, I acknowledge you then. I should also, in the spirit of the moment, also like to say that the Australian Human Rights Commission, as the National Human Rights Commission, acknowledges the profound significance of the Uluru Statement from the Heart, and we affirm our support very clearly for the Voice referendum. This is a moment of great importance in the nation's history. And thinking of moments of great importance, Pasquale, in your delightful introduction, you referred to the Universal Declaration of Human Rights. So I'm going to connect some dots of an historical kind. But before I do that, I just want to set the scene by saying for the last 4 years, the Commission has been undertaking a project that we've called Free and Equal, in which we've asked what would make an effective system for the protection of human rights in Australia. And our proposal for a Model Human Rights Act is a major outcome of that conversation. So, the scene setting. I want to take you back to 1945, the final year of the Second World War. The nations comprising the Allies against Germany and Japan focused on how to protect human rights in the wake of the horrors experienced during that war. On 26th of June, the month following the surrender of Germany, the Charter of the United Nations was signed in San Francisco at the conclusion of the United Nations Conference on International Organisation. And it came into force on the 24th of October, which is now known as United Nations Day, the month that Japan surrendered in the Pacific. 3 years before, in the midst of the war in 1942, the Allies had subscribed to the United Nations Declaration, and the aim was to establish an international organisation designed to end war and to promote peace, and to promote justice and better living for all mankind. Australia was one of the original signatories. And on the 10th of December in 1948, the body established as the United Nations adopted the Universal Declaration of Human Rights. An Australian, Dr. H.V. Evatt, or Doc Evatt as he was familiarly known, was in the chair of the General Assembly at that landmark moment. This year is its 75th anniversary. One of the UN's first goals was to provide a roadmap to guarantee the rights of every individual everywhere. In December 1946, it asked the UN Commission on Human Rights to frame an international Bill of Human Rights, and the first step was the Universal Declaration of Human Rights. What was distinctive about this declaration was its move away from an international law that was about the rights of states among themselves to an international law of human rights, which conferred rights on individual people. That great document represented the coming together of different intellectual, philosophical and political traditions into a set of common commitments for all humankind. The chair of the drafting committee was the indomitable Eleanor Roosevelt, and she is recognised as the driving force for its adoption. That moment in 1948 was celebrated and marked across Australia. The Honourable Michael Kirby FACCMG, who many of you may know, even if only by reputation, remembers clearly that the Universal Declaration of Human Rights was given to every school child in Australia on that flimsy aerogram paper that some of you may remember. The Universal Declaration of Human Rights provided the foundation stone for a pair of binding conventions in the 1960s, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. And the combination of rights guaranteed in these two covenants represent the most authoritative universal minimum standard of present international human rights law. Together with the UDHR, these three instruments are known as the International Bill of Rights. Australia was a founding signatory to each of those instruments, and as a nation, we stepped forward in embracing the commitments of these great documents. Australia has signed and ratified each of the key international treaties since then, and it has not been a party political exercise. Both sides in our system of Westminster government and in equal measure have signed and ratified them, undertaking obligations to the world. However, little has been done to enact the rights and freedoms protected by these instruments into Australian law, despite the aspirations perhaps encouraged in the school children of Michael Kirby's young years. This means that the rights and freedoms enshrined in these international human rights instruments are not directly enforceable in Australia. Our promises to the world, while genuine, are not backed up fully in practice. And the willingness to do so has also fluctuated greatly over the intervening decades. The absence of a Human Rights Act does not mean that we do not have a strong tradition of rights and freedoms. We do. And they go back directly to the Magna Carta of 1215. But it does mean that the rights and freedoms enshrined in the international human rights instruments are not directly enforceable in Australia. And this means that rights and freedoms can be conveniently distanced where the moment of politics pushes the issue. So something like freedom of speech, contained in Article 19 of the International Covenant on Civil and Political Rights, for example, is found implied in the limited freedom of political communication in our federal constitution as a legislative limit, not a positive right. It's also expressed in things like the limits on it expressed in defamation law, so what you can get into trouble for saying, and the constraints of the equitable doctrine of the breach of confidence, and the grounds of unlawful discrimination. But if you wanted to pin it down more directly, other than in hyperbole, to explain to, say, the man on the Clapham Omnibus or the Bondi tram, drawing from law students' lectures in negligence law, assuming you still have those standards in your lectures, you'd be struggling. The idea of rights is in the vibe, but it's not in law, as we saw only too well during our COVID years. From the perspective of the jurisdiction of the Australian Human Rights Commission, the absence of the implementation of the treaty commitments is also still unfinished legal architecture. When the Commission was put on a permanent foundation in 1986, the Commission was designed in tandem with an accompanying Australian Bill of Rights Act. The bill was passed in the House of Representatives, but it did not survive the Senate. And more recently, the idea was the principal recommendation of the National Human Rights Consultation led by Father Frank Brennan, SJ, over a decade ago, with its report in 2009. It also did not progress, then under a Labor government, which may have been more inclined to consider it. Institutionally then, we, the Human Rights Commission, is like a donut with a hole in the middle. Now the landscape has shifted. There is already considerable momentum in the direction of stronger human rights protections in Australia in the form of dedicated legislative embodiment as Human Rights Act in Queensland, in Victoria, and in the Australian Capital Territory. And there is considerable agitation and advocacy in other state and territory jurisdictions towards this objective too. We've also just gone through 3 years of public health measures in the face of COVID-19 and significant intrusions upon perceived rights and freedoms in consequence. In some way or another, each and every one of us has encountered restrictions on our freedom of movement, the right to protest, the ability to engage in public areas without wearing a mask, and the requirement to provide personal information for the purpose of contact tracing. Thankfully, those restrictions have now gone. But our awareness of the need for the protection of rights and the vast potential for breaching them without such protection was brought clearly into focus. Australians, generally speaking, were willing to go along with the imposition of those measures, guided by the public health advice informing the restrictions imposed by federal, state and territory governments. And for the most part, governments justified their decisions. The premiers and first ministers maintained a regimen of press conferences, often on a daily basis, that assisted some acceptance of the limits to rights and freedoms that were part of the emergency response. Although the action of the former Prime Minister in having himself sworn into multiple ministries without the knowledge of the relevant ministers or the general public did not pass official scrutiny. It led to a censure motion in Parliament and certainly did not pass the pub test. The pandemic certainly brought a renewed national focus, indeed global focus, on the importance of centralising, considering rights and freedoms during times of crisis, a greater rights consciousness. Our challenge now is to ensure that human rights remain central to government decision-making and policy design on an ongoing basis, with an embedded rights-mindedness, as I have called it, and a deeper understanding of our rights in general and about human rights in particular, and especially about what rights are protected or not under Australian law. In part, this is about the public understanding of rights, but it's also about the legal architecture for protecting rights and freedoms in Australia and the accountability of governments and public authorities for their decisions. For my presentation now, I want to focus on the case for a Human Rights Act for Australia, which is a key piece of our free and equal work. In December 2018, I threw out a sky anchor, as I called it, on International Human Rights Day in announcing free and equal. And through the national conversation we've led over the following 3+ years, we sought to reimagine Australia's framework of protections of human rights and freedoms. The title of our national conversation was drawn directly from the first sentence of the first article of the Universal Declaration of Human Rights. All human beings are born free and equal in dignity and rights. Through 2019 to 2021, we released an issues paper, 3 discussions paper, ran a submissions process. We held a spectacular national conference on human rights and associated technical workshops featuring the UN Commissioner for Human Rights, Dr. Michelle Bachelet. And we conducted a series of roundtables, technical workshops and stakeholder consultations. It has been an extensive consultative process. The project's final outputs include 2 position papers on key reform priorities and a final report to be completed this year to mark the 75th anniversary of the UDHR. The first position paper was released in December 2021. Free and Equal, a reform agenda for federal discrimination laws. In this, we set out a reform agenda to modernise our federal discrimination laws, including by remedying deficiencies in the current laws, placing a greater focus on prevention, and by introducing co-regulatory approaches that will enable governments and businesses in particular to be better equipped to prevent and deal with discrimination. But addressing discrimination alone is not enough to ensure that people's human rights are protected. The second position paper, a Human Rights Act for Australia, launched on the 9th of March this year, and it's designed to complement protections against discrimination and deal proactively with issues that discrimination laws cannot address. It presents our case as the National Human Rights Institution for the introduction of a Federal Human Rights Act for Australia and an outline of our proposed model and associated reforms. It seeks to complete the central missing piece of our domestic legislative framework for the promotion and protection of human rights by bringing rights home. And by enacting a Human Rights Act in Australia, we will catch up with every other country in the Commonwealth of Nations by introducing comprehensive human rights protections in domestic legislation. It will also fill that hole in the donut of our institutional legislative architecture. In this next little section, I want to reflect on my own journey towards considering why a Human Rights Act was a good idea. I must confess that some years ago I was a little hesitant about the idea of a Human Rights Act. I was a common lawyer, a property lawyer. I taught real property, equity, succession. Legal history is my doctoral framing. So I was very enmeshed in that sort of legal thinking. And the American experience of a constitutional Bill of Rights and litigation about rights in courts so publicly played out was somewhat discouraging. For those like us in Australia with a deeply entrenched sense of the Westminster system of government and a strong adherence to the separation of powers, such a model does not sit well, particularly the politicisation of appointments to the US Supreme Court that we have all observed. Our own constitutional drafters took a different approach from the United States. We didn't have a revolution as a propelling force in our constitutional imagining. We were more reserved. Our constitution was essentially a deal among the states to be. You have lighthouses and immigration, we'll keep health, education, you know, that sort of thing. It was a deal, dividing up the responsibilities of the states, or more particularly, what was going to be allowed to the Commonwealth. Moreover, at that time, we still regarded ourselves as essentially British. It's not that our constitutional tradition was opposed to rights, but rather it was opposed to judges having power to protect them from interference by legislation. Those who drafted our constitution preferred to place their trust in Parliament to preserve the nature of our society and regarded as undemocratic guarantees which fettered its powers. Parliament is pivotal as the vehicle of rights protection. Whether it has been able to do this appropriately is a central issue for continued reflection. So, what changed my thinking? What made me convinced of the need for a Human Rights Act in Australia? Well, it was not one specific Damascene moment, but a growing realisation in three parts. And it was also about the model of statutory rights protection that had been developed in Commonwealth countries, which retains and emphasises the supremacy of the Parliament. Step one. It was a recognition that while our sense of rights is embedded deeply in our common law, the common law has its limits. The common law also can get stuck, as has happened, for instance, in relation to protection for serious invasions of privacy. The common law in this country is stuck. The common law needs a great leap forward, as it achieved in Donoghue and Stevenson, the snail in the bottle case, but we've not got there yet. Perhaps the age of drones is the contemporary equivalent of the age of railroads to provide the necessary catalyst for the common law. But it is a slow process. Second step. We have a very patchy expression of rights protection, and most of it is framed in the negative, in terms of what you can't do. This is the way that our set of 4 federal discrimination laws work: anti-discrimination. This has also, in my view, driven some of the contemporary discourse and criticism about human rights being driven by identity politics. But you can only bring a complaint to protect yourself against an alleged violation of your rights by identifying through the lens of a protected attribute on the basis of race, sex, age, disability, and for me, as an older person who is married and female. And it's only by identifying through the lens of protected attributes that the law protects me. Our discrimination laws are also reflective of the context and times of their introduction. Since 1975, when the first of the discrimination laws was passed in implementation of the International Convention on the Elimination of All Forms of Racial Discrimination, ICERD as it's known. The political compromises which drove these laws, the discrimination laws as they were introduced, have been forgotten. After all legislation is a deal. And what was envisaged as a temporary expedient to secure passage of particular legislation easily becomes part of the permanent structure of the law without thinking, why? Why was it there? What is its purpose now? Is that purpose still relevant or necessary today? Should the protections go further? Should the definitions be consistent? These are all good law reform questions. Such concerns drove me to the work I led in relation to discrimination law reform, which was set out in the Commission's first position paper, including 38 recommendations for reform, building on and going further and comprehensively from Respect at Work, which was about sexual harassment in their workplace. Step 3 in my journey was the realisation of the effectiveness of the complaint handling jurisdiction of the Commission, which it has had since its very first days. To give you an idea of that jurisdiction, the Commission is contacted by, on average, at least in pre-COVID times, 15,000 individuals and businesses a year seeking information about rights and obligations under federal discrimination laws. They are assisted or referred, and in some instances proceed as complaints. About 2,000 individuals each year pursue the formal complaints process. So 15,000 inquiries, 2,000 complaints. Again, based on pre-COVID numbers, but it gives you a sense of the scope. And the complaint handling is based on alternative dispute resolution. Only a tiny number of those complaints ever end up in court, on average 2 to 4% a year. And most participants, both those who complain and those who are complained against, are very satisfied with the professionalism of the process and its outcomes. If we look at the number of complaints the Commission received and conciliated over 20 years up to 2018, for example, the numbers represent successful alternative dispute resolution through conciliation for more than 30,000 people and organisations. The process can also achieve many positive systemic outcomes through the conciliation process itself, that is the heart and soul of the complaints handling process and the principal vehicle of the operation of discrimination laws. Moreover, analysis of the cost impact of the services provided, rather than through a court process, suggests significant savings. Private costs in having matters conducted through the Commission are minimised, typically through limited involvement of lawyers, and there are no costs of making a complaint. There are public costs of providing the service, but compared to the public cost of court time and private costs of legal fees in a litigation context, the difference is considerable. At one time, it was estimated as being a saving of up to $200 million a year. Where the law can work well, and indeed much better, is where it frames the way people and workplaces interact, that they are respectful of difference, that decisions are made in light of the impact they may have. And this is where the discussion about making decisions through the lens of a human rights-based approach comes in. This is a focus not on litigation and courts, but upon the upstream area of making decisions and making laws that are respectful and have the least intrusion on the rights and freedoms of others. This is what human rights proportionality analysis is all about. Human rights-based thinking, through a range of mechanisms, is the kind of law reform that can make a difference. In our position paper, we conclude that the existing mechanisms are insufficient and do not provide the human rights protections that all people in Australia are entitled to. It expresses at a personal level the completion of my journey as to why a Human Rights Act is indeed needed. The COVID-19 pandemic showed how important human rights protections are in times of emergency and uncertainty. They help us to discern our priorities, to make difficult decisions that respect human life, and also ensure that other rights are not unnecessarily restricted. As we leave the pandemic behind, touch wood, it is clear that strong rights protections are needed and wanted to help us navigate our collective future, both through times of calm and in times of crisis. Our experience with royal commissions into robo-debt and the abuse experienced by persons with disability and in aged care have exposed egregious human rights abuses and show how our existing systems are just not adequate. The experience during COVID also reinforced the need for greater protection of human rights up front in the policy-making process. The need for better human rights protections in Australia can be summarised by one simple proposition. We should have proper protection of human rights at the national level because everybody's human rights matter all the time. To do so requires that human rights are embedded within the laws of our country so that they have practical effect for individuals and are consistently and coherently applied by government. A Human Rights Act would ensure that the rights and freedoms that Australians rightly expect and assume are protected are in fact protected. 2 states and 1 territory now have Human Rights Acts. They have made valuable contributions to the law, policy and decision-making processes in those jurisdictions. At the federal level, the Australian Human Rights Commission has been handling human rights complaints since 1981 through the lens of the international treaties. This is a different jurisdiction from the discrimination law pathway. We seek to resolve complaints about breaches of human rights through conciliation. But unlike the unlawful discrimination pathway, people who complain that their human rights have been breached cannot obtain enforceable remedies through the courts. This seriously limits the effectiveness of conciliation and the willingness of public authorities to engage. Human rights are not always respected and protected by governments, and failures to protect human rights can affect all kinds of people, and any lack of respect for human rights degrades society at large. And often those most harmed are the most vulnerable among us. And look at the cost when the protection of rights, and particularly in relation to vulnerable people, has broken down. For example, the Law Council of Australia suggested that the Royal Commission into Aged Care will cost the Australian government $104 million over 4 years. The Royal Commission into Institutional Responses to Child Sexual Abuse cost about $500 million. The Royal Commission into Violence, Abuse and Neglect and Exploitation of People with Disability will cost $527 million. And the Royal Commission into the Protection and Detention of Children in the Northern Territory cost $54 million. The cost, when you get to that point, exposes the failings from the beginning. The failing from the beginning is to make decisions, to design policies, and to implement practice through the lens of human rights. And that administrative detention in our immigration detention centre context, that indefinite administrative detention is not unlawful under our existing laws, suggests why our current protections are just not enough. The Human Rights Act model would build on the experience of complaint handling of the Commission over 40 plus years and address the weaknesses of the current scheme. In particular, it will provide a pathway to enforceable remedies and would substantially improve, in that way, access to justice and accountability for government decision making. It would provide a greater incentive to think about human rights early when decisions are made and before they become complaints. It would be an evolution, not a revolution, in the Commission's ability to handle and respond to complaints. Our position paper offers a clear and concrete set of proposals to implement a Human Rights Act federally, and it's tailored to the unique legal framework at the federal level. It will also complement the existing human rights protections in 2 states and 1 territory. Our model retains and emphasises the supremacy of the Parliament. It's a model that's been described as a dialogue model, the dialogue between the 3 branches, the executive, the legislative and the judiciary. The possibility of court proceedings is included because without it you don't get the accountability leverage you need for improving decision making. But litigation is not the point. It is the positive duty on public authorities to get it right in the first place by developing policies and framing decisions through the lens of human rights. The beauty of a Human Rights Act and other measures that front-load what I call rights-mindedness is that they are expressed in the positive. They are embedded in decision-making and ahead of any dispute, and they provide a way of resolving intersections between rights through a proportionality framework. A Human Rights Act names rights, it provides an obligation to consider them, and a process by which to do it, together supporting a cultural shift towards rights-mindedness becoming part of the national psyche, not just an afterthought. The model that we put forward draws on the comparative international models and the ACT, Victorian and Queensland ones. It builds on the excellent work of the National Human Rights Consultation Committee, the one under Frank Brennan that I mentioned, and the research and advocacy of the Human Rights Law Centre, the Law Council of Australia, Amnesty International and many other community partners for bringing rights home. It is a model also that is entirely different from that in the US. The possibility of judicial consideration is there, but litigation is not what it's about. I thought to finish I would just bring in a reflection prompted by my eldest grandson. A number of years ago, when my eldest grandson, then aged 7, spotted the Magna Carta on the wall in my study. It's a lovely facsimile produced by the Rule of Law Institute in 2015 to mark the 800th anniversary of the sealing of that landmark document. Notice I said sealing, good trivia question. It was sealed, not signed. My grandson, rather impressed, said, "Grandma, you have the Magna Carta on your wall." How did he know about it, age 7? Through horrible histories on television. A story of King John being nasty, exceeding power without accountability to Parliament. But how does this lead to a conversation about rights in Australia today? It is hardly the Universal Declaration of Human Rights that young Michael Kirby took home. The Magna Carta is not what you might describe as a highly accessible document. In the medieval Latin of the early 13th century, it is iconic, perhaps the vibe of our understanding of rights, but over breakfast with your grandchildren. On access to justice, how about this? Nulli vendimus, nulli negabimus, aut differemus rectum aut judiciam. To no one will we sell, to no one will we refuse or delay right of justice, access to justice. Human rights-based approaches give us the legal grammar for approaching complex balancing issues. It provides a greater embedding of our promises to the world in Australian law and the pathway to do so. A Human Rights Act for Australia is a missing piece in our domestic implementation of our promises to the world. In this year, the 75th anniversary of the Universal Declaration of Human Rights, we have the moment to seriously begin a process of bringing rights home. Thank you.